The report of the Public Protector into the CR17 campaign and the President having misled Parliament has been set aside and ruled as invalid, including the findings and remedial action. And she's been ordered to pay punitive costs in the presidential successful challenge of her report. Plus, the Public Protector ordered to pay the costs of the NPA Parliament in challenging this report. Judge Elias Matojane found that the activities of the CR17 campaign were those of a private individual and did not make use of public funds. The court also found that the Public Protector Busisiwe Mkhwebane did not have jurisdiction to investigate the campaign. For the latest on that story, let's go live now to our editorial contributor Karyn Maughan in Pretoria in Parliament. Karyn, the Public Protector losing every single aspect of her case today. It's a bloodbath.
Well, we're joined now by President Cyril Ramaphosa's attorney, Peter Harris, who will be speaking about your immediate reaction to what was absolutely a clean sweep for your client. You won on every single aspect of your case.
Yes, look, I'm not going to comment much, just to say that it was a resounding victory for the President, and entirely justified, an excellent judgment, we thought. And the fact that a punitive costs order has been granted against the Public Protector, we think is necessary. I think in doing so, the court obviously made a clear statement of its disapproval. The number of adjectives used, or negative adjectives used to describe her conduct were significant, unlawful, irrational, reckless, not showing partiality or an open mind. I think that those are very sad reflection upon the current occupier of the office of the Public Protector. In fact, if it weren't so tragic, it would almost be a joke.
Peter, just on one last point, we know that the Public Protector fighting in court next week to halt the inquiry into her potential fitness to hold office. This matter was brought into that case where the President said that in light of this litigation, he was indeed conflicted in terms of a possible suspension of her. Does that change in light of the President's now resounding victory in this case?
I'm not going to comment on that case. I'll leave it for others. Thank you very much.
That's Peter Harris, of course, for President Cyril Ramaphosa. We're now going to be joined by Oupa Sekghalwe, who is also going to be speaking to us about the outcome of this decision. My colleague also from the SABC. This is a bit of a messy press conference because we're all here trying to talk to the officials involved.
All right, I can hear you.
Oupa, if you
speaking to the Public Protector
spokesperson. So, Oupa, just your reaction.
Well, I think this was a very extensive judgment. I think it runs into around 100 pages. So what will not be advisable for the Public Protector to do at this point in time is to offer a knee-jerk reaction. I think it will be proper for her to rally her legal team and study the ruling, understand it, especially the reasoning behind what the full bench said here today. And then at that point, she will be in a position to opine substantively on the judgment as well as indicate what the next step for her will be.
Essentially, it was a clean sweep for the President on all key points that we argued here. The Public Protector has lost, and this is yet another high-profile court matter that the Public Protector has lost. What's going on there?
Well, as I said, she will have to, go through the judgment with a fine tooth comb to understand the reasoning, because she thought that her counsel representing her a month ago put her case in a very strong manner. She wasn't anticipating this kind of a ruling, but as I said, she will indicate whether she will take any steps going forward with regard to this matter. But obviously, it's a disappointing judgment, and she respects the judiciary as well as the judiciary's authority to make these kind of rulings. But of course, respecting a ruling does not mean you must agree with it. You can hold a different view, and you have all these other avenues to explore with the view to possibly arriving at a different conclusion. But I'm not saying she's going to appeal, because she hasn't taken that decision yet. That decision can only be taken after a thorough study of the judgment.
How can the Public Protector believe that attorneys made a strong case when they were criticized, the arguments were criticized so extensively in this judgment?
Well, it would be, of course, based on previous authorities. This very same court has previously made, similar, or has made rulings on a similar case. For instance, if you look at the state capture judgment, you will see that in the remedial action, the executive was directed to take certain steps to establish a commission, to appoint a chairperson. You will notice that there were certain things in that report that were referred to the NPA. You will also notice that Parliament was directed to do something, and that was to review the Act, the Executive Members Ethics Act, and that matter was brought before this court, and this court ruled that that remedial action was sound, and that was the basis of some of the Public Protector's decision and the arguments advanced by counsel. But obviously the court viewed those differently, which is why I'm saying the Public Protector will have to rally her legal team and give themselves time to study it thoroughly and then map the way forward.
Opa, this is the latest court to question the Public Protector's partiality, to signify or to determine that she doesn't seem to have a basic grasp of the law. She confused the law on money laundering with that of corruption. She didn't seem to have an open mind, the court found. This is like the fourth or fifth very, very damning ruling made against her. In light of all these things, in light of the fact that these courts continuously raise issues of her competence, does she believe she's going to be able to stay in office if there is an inquiry into her fitness?
Yes, she does, because she does not believe that the reason for one to stay in office must be based on the merits of her investigations or even the arguments she brings before court. Because if that was the case, then even judges would stay on the bench would be threatened, because courts criticize even judges time and again to say, you were unreasonable here, you misapplied the law here, and so forth. So if that has never happened to anyone sitting on the bench, why then should it happen to a Public Protector? That's her position on the matter.
Does she believe she'll be able to block this inquiry from happening when she goes to court next week?
That is another misunderstanding. The Public Protector has no interest in blocking the hearing.
Yes.
She has questioned the rules. She is unadvised that the rules are unlawful and unconstitutional. So once that question has been addressed, she's happy to participate in the inquiry. She has no qualms with the inquiry. She understands that in terms of Section 194 of the Constitution, Parliament has that power to hold her to account in that way. And she has no beef with that whatsoever. Her problem is that the rules, as she has been advised by counsel, are invalid, null and void. And that's the argument she will be advancing before court. And then once that matter has been settled, then the inquiry can proceed.
Does the Public Protector, as we stand, do you think she still has any sort of a form of credibility? And can the public still trust her when we are seeing that it's the Absa Bank Op case, we had the Estina Dairy Farm matter, and now we have another high-profile Bosasa matter, all reviewed and set aside? How can the public continue to trust a Public Protector that seems to be losing on key investigation that she issues?
Well, I think the question you should be asking is whether, if this matter was decided by a court and a senior court found that the findings were irrational, would you say then that the court has no credibility? It doesn't work like that. That's why I've been saying you cannot say a person is incompetent on the merits of the case that she has advanced. If you say that, then you should be prepared to say it in respect of the courts. There are a lot of high court judgments that get overturned by the Supreme Court of Appeal and the Constitutional Court. So it can't be that when a court decides that there has been a misreading of the law here, irrationality here, therefore the person is not fit to hold office. There have been Public Protectors before who have had their decisions set aside on the grounds of irrationality, misreading of the law, and so forth. So let's not have one set of rules for some people and a different set of rules for the others. Thank you.
Thank you. That was Opal Sekhwale, of course, from the Public Protector's Office, just reacting to that decision and really making it clear that, at this point, the Public Protector still needs to consider her options in terms of a possible appeal. Of course, we know that this judgment is going to have a potentially big impact in terms of the decision or the application by the Public Protector next week in the Western Cape High Court to halt that inquiry into her fitness to hold office, pending her legal challenge to the rules that could govern such an inquiry if and when it goes ahead. But certainly, quite strong words coming from Cyril Ramaphosa's attorney saying that what has happened here would be laughable if it was not so sad.
Yeah, Karyn Maughan, what exactly do we hear the courts saying about the powers of the Public Protector in investigating internal party activities and the funding?
Well, essentially, they agreed with President Cyril Ramaphosa's lawyers that essentially that kind of issue is not involving state funds, that it was really not within the ambit of the Public Protector's jurisdiction to probe that kind of funding because it didn't involve the mandate of her office, which is, of course, to look at potential state abuses. Public Protector had contended that she believed that, this may amount to some form of state capture, this large-ranking sponsorship of a political figure, and that was why she investigated. But the court ultimately here saying she had absolutely no jurisdiction to do so, and that her decision to do so was invalid and should be set aside.
And a big part of it, of course, is her finding on the money laundering issue that she raised, and the court's finding that she was actually reckless in even reaching that conclusion because there was no evidence put before her that would suggest any kind of money laundering activity.
Well, it actually gets worse than that because the court here is saying that the Public Protector had used the wrong piece of law to make her findings around suspected or implied money laundering involved in the CR17 campaign. That in fact she had used PREGA and not POCA, which is the Prevention of Organised Crime Act, to make her determinations, and this was simply not appropriate or legally sound. As Pierre de Vos put it on Twitter, this was akin to using hate speech legislation to prosecute or potentially investigate a traffic offence. It also went farther and said just outside the ambit of the law and the law that she used to make that finding, there simply was no evidential basis for her to make a finding of money laundering. That money laundering, under its specific criminal definition, is the deliberate concealment of funds that have been obtained unlawfully in criminal activity. And there was simply no basis to say that was the case. Remember, the Financial Intelligence Centre in its affidavit to this court saying that it had specifically not made any finding of money laundering because it could not determine the source of the funds that Ramaphosa's campaign had found. The court also pointing out that these were private funders and that the source of that this allegation that multiple accounts were used was simply not sustained by the actual facts.